So, I guess the next thing on the list is bold. We talked about it already. Businesses going through probate. It's a no-no. It's a big no-no. You're going to waste a lot of money. You're going to disrupt your business flow. You're going to get the wrong people in control. You're going to have valuation issues that are going to be fought over by the various parties. I forgot to mention something in the last thing about challenging. You mentioned how do they know? How do they do it? So I mentioned the arguments of undue influence, lack of capacity, invalid execution. I forgot to mention these people are generally. I forgot to mention two things. These people are generally required to get notice. That whole due process thing.
Yeah.
So you have to tell them. You have to say, here's the will that you got cut out of. Here you go. Go find your attorney. I'll hear from you in 20 days. So you have to tell them. But do you? Maybe not. If it's a will and it's in an estate, they have to get notice. If it's a trust, which is private, and if it's done right, it's executed before death. It's called an inter vivos trust. It's a lifetime trust. And you cut someone out, there's no notice requirement to give. There's no notice requirement to give notice to the person who's cut out in a trust, like there is in an estate. So that's one interesting thing about the notice.
Unless it's a surviving spouse, right?
Well, yeah. If you cut out your spouse and go back to the thing I just mentioned about the
How's that? Sorry, clarifying for everyone listening.
You go backwards. Yeah. So there's that, and there's also another interesting thing. If you do a trust, you're a young guy. You pass away in 70 years from now, and you have a trust. Every transaction that you've done during your lifetime after that trust was created, but before you pass away, is like reinforcing your capacity. It's reinforcing your intent. You're not just waiting until death in the death court, the toll booth, to challenge, your capacity, to challenge your influence and your intentions. Like you've been doing that this whole time, and that's an important factor that I think.
While we're talking about trust, something came to mind.
Yeah.
I saw this happen with a client. Let's say someone creates a trust, but they never actually transfer anything into the trust. What happens then in terms,
Happens all the time. A lot of attorneys, they just get, here's your docs, get the hell out of my office. They don't help you marshal assets over to the trust. Sometimes it's intentional and strategic. But basically, if you don't fund the trust, it's going to go through probate. And if usually you have what's called a pour-over will, where the will says everything that's in my name still, send it over to the trust. So everything goes like this to the trust. Everything goes to the trust. But that happens in probate. So you're still going to do probate, but hopefully the pour-over will that says go to the trust. The worst thing you can have is you have this awesome trust, really well thought out, but nothing in it, and no pour-over will, no will, and you have an estate that goes this way, and a trust that goes this way that has nothing in it. I mean, that's kind of like the worst thing. So I wouldn't do that.
Haimo